Well, I'm going to stop that as a section after the doorbell rang, and I'm now going to call this Advocacy chat number 6, I think it is, and I'm going to move on to now leading questions. Right, this is where you ask a question which basically is leading on the answer. Normally, leading questions you can, by agreement, lead. Like, for instance, you call the witness and you say, well, do you refer to the 15th of March at 10:45 in X Road. Everybody's quite happy with you leading with it. It's not a matter in contention. So, provided you've got the agreement on the other side and there's nothing, and it's relevant and it's not a matter in dispute, you can lead on it. If you've got any doubt, you ask the opponent, and if it comes to it, you have to have a debate about it. But very often you hear an objection, you say you're leading. You can come across an opponent. Let's take an example where an opponent says to you, I don't want you to lead at all. Not anything, not one question. I really do not want you to ask this witness anything that's leading. So you stand up. So you can't ask about the date, you can't ask about the time, you can't ask about the road. So you've got to think of a question. I'll give you a couple of seconds. Witness in front of you. You want to start asking questions about an event, but you don't want to lead. Got the answer? Well, here's one answer. Mr. So-and-so, Mrs. So-and-so, Miss So-and-so, Mrs. So-and-so, do you know why you're here? You're away. So there are a few questions you probably get away with, which are general ones, which are worth remembering if you're stuck for anything. What happened next? What time was this? Where were you? What did you see? What did you hear? And so on. So there are some questions you could even have available to you when you first start. Also, very important, avoid speculation. Avoid asking a question which you're asking the witness to speculate on the answer. So why do you think he actually said that then? Well, how would they know? It's asking to speculate about what somebody else was saying or thinking. Why would he think that? That's clear speculation. Often you hear it too, but strictly it's wrong, and I would dispute that anyway. Cogent questions are important. Clarity. Remember, juries come from all walks of life, using long words. Even the judges come from all walks of life and education. It might well be that most of the judges that sat around me in the Northern Circuit had classical educations, but I certainly didn't. And I certainly wasn't taught Latin. And I do remember, I can't remember the phrase now, but a barrister stood up and said, yeah, so-and-so, you want to... I can't remember the phrase, but something like res ipsa loquitur. And I looked at him and I said to him, well, I don't understand what you're telling me at all. I said, I don't understand what you're saying to me at all. I said, and if I don't understand it, I don't know how many there are. I'm sure how many of the juries understand it, and all jurors sat there, all nodding their heads in agreement. None of them understood what he was saying, and so you've got to phrase questions, and your closing speeches and your comments that you want the jury to hear in a way in which that it's understandable and clear. Don't say things one at a time. I would suggest, rather than 5 or 6 things all at the same time. And the same thing often applies to judges. And the other thing is, sometimes with judges, I found that people addressing me go far too fast. I mean, if I'm making a note, it'd be nice if the pen was followed. It doesn't matter so much now because I touch type. Now, one of the problems about technology, because I can't talk about how they're used in court now, but I can talk about typing. And that is that if you're typing, you can't see what's going on around you unless you can touch type. So I think the observation, physically seeing what's going on around you and people's reactions is important. So you have to try and get the balance in your note taking as to how best to do that. Anyway, and not least of all, with technology, you can always lose the screen goes blank. I mean, I've had that several times. And you've got to try and find it again. I've had it once where I could never find it again. I had to do it all from memory. So what's your duty then? Well, to test the evidence, test the veracity, test the facts, put your case. I mentioned already the final question, which everybody tends to say to, in the hope that it covers the point if they haven't done it already. I don't think it's a good idea. Make sure you get it. Make sure you get it right. Anything that's happening in the case, which there's a number of different lawyers, I said before, explain to your client why you might look different from the other lawyers. Why what you're saying and what you're doing is different to the others. You will notice that. I mean, it could be a multi-hand case, say 10 defendants, and nothing affects your client for, say there's 1,000 pages, only two pages relate to your client, if you're fortunate. You know, you can't ask every witness a question, so you've got to explain to them that you're going to be sort of doing the crossword puzzle for a large part of the time. Now, terms of cross-examination, lines of cross-examination, you need to know your subject too. So if something's technical, you need to do some research. You could put, so if you're cross-examining a witness, you've got your own witness possibly in court, or you've been through the evidence with them or her, you know, you need to know how to cross-examine. I mean, some things, identification's classic, so you've got timing, weather, how long it was for, the weather, the lighting, obstructions, all of that is part of the cross-examination. And now, cross-examining expert is different. I mean, I just want to mention DNA. I'm sure some of you must go on courses for DNA, but I've got to say this: I've got no relationship with Michael Mansfield at all. But when I read his book Memoirs of a Radical Lawyer, there's a section he discusses DNA and cuts through the technical jargon. I've got to say it really was. I found extremely useful explaining to me a general view of how DNA actually works. So he'd done research and I got the benefit of it. Also with experts, I often think it's worthwhile looking at the expert and making sure they are an expert. They may not be an expert. They may not even be giving relevant evidence. I'm just trying to think of some illustrations of that. Yeah, in the old animal cases, RSPCA cases, they trooped out some sort of psychological expert on animal welfare or something. And when you looked at his degrees and the expert's degree, he had no relevant degree at all. So it's worth looking at that. And the expert evidence, I always think that if you've got something very complicated, try and bring it down to, if you can get the expert to put it in diagrammatic form. I think that's worth considering. Tools to explain things are a great idea, depending on what it may be, photographs and so on. Photographs, of course, another thing where you'd use evidence of photographs. You know, get a professional photographer. You know, get the photograph right. If you want to show something was a long way, you don't try and get it to look realistically a long way. I mean, don't sort of doctor photographs or anything, but you know, take photographs or get them taken by somebody who knows what they're doing. Now, we discussed the question of experts in animal cases, and I suppose that's sometimes they can be quite amusing in those cases. So I'm going to turn to humour now. Humour in court. Now, not everyone can tell a joke. Not everyone can ask a sarcastic question without it sounding rude. You've got to play to your character. You all know if you can get humour in court and it goes down well, the case is right. I can't see there's anything wrong with it. Just keep an eye on the judge while you're doing it is what I'd suggest to you. So let me just think of odes. I used to love odes, but not being a Crown Court advocate because my odes were very much in the lower court. So let's just say there was I can't remember all the facts of these things as well, but let's just say I was doing a case in which 6 or 8 officers gave evidence of arresting my client in a restaurant on an evening, and they were all charged like there was 4 defendants or something, or 2 defendants, and there was 8 officers and 8x2 perms of assaults and public order offences. Anyway, I cross-examined all these 8 officers, and I got 8 different versions effectively. And so I said, I have in my speech a little ode, a little ditty, what I have penned, and I dedicate it to the 8 officers sitting at the back of court. And it goes as follows. What happened on that June night was within 8 officers' sight, but upon what they saw they cannot agree, and very confused they seem to be. So to prove my client gives someone a clout is impossible beyond reasonable doubt. So the view of my client's plea, a not guilty verdict, it surely must be. Now, not brilliant. I wouldn't say it was going to win a literary award, but, you know, it often sort of sums up the case quite well. There was one more ode. I used to do so often, but I can't remember all of them. There's one though that was where a chap was persona non gratis with the local police, really, and he was in the cells, and any practitioner, or certainly in my experience, I can only talk about my experience. It may be changed now. It may be different now. But if you're in the cells, you used to have a little bell, a little button that you pressed if you wanted attention. But very often that bell was switched off in my day. And of course, one had to bash on the cell door. And of course, my client was in the cell. He was bashing on the cell door, and the trap door fell out and broke. So they charged him with criminal damage to the cell door, gleefully. Anyway, so it was all about foreseeability and so on about the criminal damage. So I said, Southall Police had a steel door, steel, metal, designed to be secure. But to gain attention, one had to tap. Who could believe that out would fall the trap? So Southall Police now rue the day they invited my innocent Mr. X to stay. Well, there we go. That summed it up perfectly well. Don't need much else in cases like that. There are cases, of course, where you put the prosecution in a position where they may want to drop it. I mean, certainly the prosecution always got a problem where there are participating informants, and they may not want them disclosed in drugs cases. That's something which does arise in drugs cases, particularly as part of your defence. But I was thinking more in terms of, but the case was so ludicrous, you wonder why it was brought. Very often these cases are sorted out before it comes to trial, and they are dropped. But there was a search warrant executed, and in relation to stolen property. But while they were there, they found an owl and a ferret, and the owl was in a cage next to the ferret. And the police officer, one of the police officers, was really interested in wildlife, and so there was a causing cruelty to animals. So it was so in respect of both of them. So in respect to the owl, it was an allegation to that the owl was sat in the cage and was suffering stress from being able to see the ferret and not being able to eat it. And the ferret was suffering acute damage to its well-being by seeing the owl and being scared that the owl might wanting to eat it. Well, it was psychologically cruelty. Now, I can't tell you the name of the solicitor, but if I was to suggest he had a name in relation to birds, that would be just great. Anyway, so I phoned him and I said to him about the night before, and said, I'm looking forward to court tomorrow. I said, we were talking about something else actually, but anyway, I said, I wonder if the press will be there. Anyway, by the time he came to court in the morning, he decided to offer no evidence. He saw the reality of the fun that one was going to have. And then things like, again in my ramble, sometimes it pays to have, in the right case, examples to illustrate little, what would you call them in acting? I suppose props, you'd have them. Props is the word I was looking for. So I remember once a theft of a tomato plant or something, and I put 4 tomato plants, saying how difficult it was to identify the tomato plant in question that was recovered as being the one that was stolen. And then there was another one where drugs were found in a Swan Vesta case, which was matching boxes in those days. And basically the defendant was searched. He'd been in the pub, and in his matchbox was found some drugs. And good Lord, you could have knocked him over with a feather. He must have picked up somebody else's box on the bar. He didn't know that he had drugs in it. And of course, it was a good illustration to put 6 or 7 boxes of Swan Vestas on the thing and say, I've got a £5 note in one of those, and it'd be very difficult to tell which one had the £5 note. Anyway, so there's that. And I think, again, well, I'm just rambling for these funny cases. In the early days, after cars came into existence, the police used to have panda cars at the time, and they used to hardly ever go to the country, but now and again they did. And I had a defendant charged with being drunk in charge of a horse, and his defence was, I asked him what it was about. He said, I tell you what he say. He said, I went to the pub on my horse. He said, like me granddad did, and me dad did, and my great granddad did, and I get well plastered, I get on the horse, and the horse takes me home. So we ran a defence. I ran a defence on the basis that the defendant was never in charge of the horse. At all times, the horse was in charge of the drunk, and I think he was convicted on that. But anyway, it was a no sentence. But there are some times where you can get the right case that everything works very well in it. Now, closing speech is very important. The law in the closing speech, yes. The relevant law in Crown Court, yes. But remember, the judge will be covering that. Lay magistrates, you've got to make sure it's absolutely classically clear that they know what they're dealing with. And I said to you earlier on, it very often pays to have a little booklet of what you say the law is, and get the prosecution to agree it. Do remember that professional judges do know the law. They don't need to be lectured on stuff which they deal with every day. You can ask as well professional judges, district judges, for an indication before you address them, saying a guilty plea. I'm not referring to the indication in terms of sentencing. In relation to the prosecution, I can't say much about prosecuting, having done not much of it, but it's very important there. I think more important than anything else to make sure that the checklist of everything you need to prove is ticked off as you go through it, and to take out all the evidence which is unfair, irrelevant. Unfairness, of course, is an issue too. There's a duty on the Crown which is different from that on the defence. And I mentioned earlier on, I said the need to keep certain bits of law available near to you. Can I also make a suggestion that you keep a little crib sheet of dealing with mentally challenged or ill defendants? They do turn up. There are psychiatric cases that turn up. You need to have a little bit of knowledge about psychiatric disposals, psychiatric reports, and psychiatric defences. So there we are. I've covered a little jaunt through advocacy with a few anecdotes. It's not where it conflicts with anything you're taught in a proper environment, then please ignore what I'm saying. not least of all because what I'm saying is dated in many ways, certainly as far as the law is concerned. Anyway, I hope that that was enjoyable. I'd like a few comments, constructive comments, please, and let me know what you think. Okay, thank you very much, and good luck to you, all of you, in your careers as you commence them. And my career, of course, has come to an end, and I thought I'd just record a little bit of this whilst I still remember, as I said earlier, my name and address, because who knows how long I'm going to remember that. Thanks a lot. Good luck to you all.